All have joined? Yeah, let them come. No hurry, no hurry. Let them come. Before jumping to dwelling into this next Money Laundering Act, just Money Laundering Act already been in detail. We have already dealt with that. And before that, I just want to refresh your memory with respect to the Section 3 alone, because I got that amendment also here. Section 3 provides that the central government may constitute an agency for the purpose of special agency to be called National Investigation Agency for investigation and prosecution of the offences under the Act specified in the schedule. We will have to look into the schedule also. Then, what 3.2 says is, along with the amendment I am saying, 3.2 says, I will just read it out, I explained already, subject to any order which the central government may make in this behalf, the officer of the agency shall have throughout India, in relation to the investigation of the scheduled offence, powers of persons concerned of such offences, all the powers, duties, privileges and liabilities which the officer in connection with the investigation of the offences committed therein, and subject to the any international treaty or domestic law of the concerned country outside India. The jurisdiction goes outside India also. I will once again read it. This is so important. Please bear with us, and please, this is so important. Section 2.2. This after 2008, the amendment was carried out in 2019. This amendment says it shall be inserted after India, throughout India. That is a word called throughout India is coming here. After the throughout India, this word has to be inserted. Then I am reading it along with that. Subject to any order which the central government may make in this behalf, the officer shall have throughout India, in relation to the investigation of the scheduled offence, and subject to any international treaty or domestic law of the concerned country outside the India, shall have all the powers of arrest of a person concerned in such offences, and shall have all the powers, duties, privileges and liabilities which the police officer have in connection with the investigation of the offences committed therein. This is how the jurisdiction goes out also, and the power of the investigation officer also is extra territorial in nature, beyond the territory of India also. So now we will come to, because this power has been given as per the international treaties. Now if you come to the 3.3, the same officer is invested with the powers, that's a power that is exercisable by the officer in charge of the police station throughout India. This is a 3.2 and 3.3 which you have to bear it in mind. Now straight away we'll jump to the schedule offences. What are the acts? What are the offences which included in the act, which acts that's been included in the schedule? For that we'll have to go to the schedule. Schedule also has been amended. Earlier Explosive Substance Act was not there. Now Explosive Substance Act also had been added along with the schedule. Then Atomic Energy Act, UAPA Act, Anti-Hijacking Act, Suppression of Unlawful Acts Against the Safety of the Civil Aviation Act, SARC Convention, Suppression of the Terrorism Act, Suppression of the Unlawful Acts Against the Safety of the Maritime Navigation and Fixation Platform in Continental Shelf Act 2002, Weapon of Mass Destruction and Delivery Systems Prohibition of Unlawful Activities Act 2005, and offences under the chapter number 6 of the Indian Penal Code, that is 121 to 130, both included, which is offence pertaining to the war against India. Any conspiracy for the purpose of waging a war against India is also included in that. So therefore, in all means we will have to take into consideration, and also the subsequently 489, that is pertaining to the counterfeit coining and counterfeiting of the notes, coinages, etc., for the purpose of destabilizing the economic viability and condition of the India. If such an offences are committed, and if currency is going to be drained outside India, or some other currency is going to be drained inside the India, it may affect the economic stature of the India. Therefore, the acts that's been included in the schedule has been coined for the purpose of seeing that what would be the implications of the offences which affects the international ramification and the national ramification, and it will have an effect of cross-border terrorism. So this is how the schedule has been schemed. So this is up to the NIA. Then we will go to Prevention of Money Laundering Act. In the Prevention of Money Laundering Act, it's already been dealt with very elaborately, and therefore I am confining myself with the object and reasons, which the first page itself says. The Act provides for, I am reading out for your purpose of understanding, which already I have said, there is an international convention in the year 1990 and another convention in 1998 for the purpose of controlling the money laundering outside the India, which will also paralyze the economic welfare of the nation. Okay. So this is an act to prevent the money laundering and to provide for confiscation of the property derived from, that is the proceeds of the crime, derived from and involved in the money laundering, and for the matters connected therewith or incidental thereto. Whereas the political declaration and the global program of action annexed to the resolution number 17/2 was adopted by the General Assembly of the United Nations as its 17th special session on 23rd day of February 1990. This is the first resolution. And whereas the political declaration adopted by the special session of the United Nations General Assembly held on 8th to 10th of June 1998 calls upon the member states to adopt national money laundering legislation and programs where it mandates. This declaration, political declaration in the year 1998, mandates all the members who have participated in the declaration to create and adopt and money laundering legislation itself. Legislation, they are saying specifically legislation, not the policy. They are specifically saying legislation and program. And therefore, in view of these two international declarations, the declaration of 1990 and the declaration of 1998 made the Government of India, Central Government, Union Parliament to enact the law of money laundering to prevent the money laundering and to deal with the offences which is purely coming under the Ministry of Finance. Earlier, MHA, this NIA will come under the MHA, as well as CBI also will come under the MHA, and the narcotics will come under different ministry. Okay, this is the object and resolution which has been stipulated in the Prevention of Money Laundering Act. The third one which I want to highlight is in the money laundering offences, scheduled offences. We already earlier we discussed beautifully about the proceed, what is the proceed and what is the basic offence. Only if the basic offence is going to be proved, then the second offence, the money laundering offences, will be deemed to be proved. Otherwise, no, it will not be deemed to be proved. Once a basic offence is not proved, the money laundering offence will not have legs to stand upon. It will vanish. It cannot be punished for that. So, for the purpose of punishing in the money laundering, that I am in the possession of the proceeds of that crime, the crime has to be proved first. What is the crime I have done? So, all these crimes and the offences relating to that, offences with reference to the acts, all the acts, what are the acts which are covered in the money laundering, are all mentioned in the schedule here. Here in the schedule, here also it includes waging of the war, Prevention of Corruption Act, and other offences under the Narcotic Drugs, offences under the Indian Penal Code, offences of Arms Act and Wildlife Act and Immoral Traffic Act and Prevention of Corruption Act. In all the ways by means of which the money could be accumulated and it could be settled, or property could be purchased, it could cross the border and it will become a property outside the country. It may be in France, or it may be of Dubai, or it may be of Singapore. It goes like that. So, what is included in the money laundering are the acts pertaining to the offences. This is a basic offences. Only if the basic offence is going to be proved, then the money laundering will be proved. If you do not So therefore, the special courts also has been constituted for the purpose of joint trial of both the cases. There are some different judgments are already highlighted in one of the lecture also I heard. The Jharkhand High Court has given a different version that it could be tried differently or something like that. But if it is so connected to the crime, if it is inseparably connected to the crime, both can be tried together, and to that effect the powers have been given in the Act for the purpose of transferring the case to the special court for the purpose of trying it. Okay, this is the second one. Then in the narcotic drugs, if you could see the section 2 definitions, narcotic drugs, in the narcotic drugs, please come to the definition in the section 2, and where in the subclass 9, the international convention pertaining to the narcotic drugs had been mentioned. The international convention means wherever it is stipulated thus in the international convention, it means that the single convention on narcotic drugs that's been effected in 1961, adopted by the United Nations conference at New York in March 1961. The protocol amending the convention mentioned in the subclass and A, adopted by the United Nations conference in Geneva in March 1972. Third one is the Convention on Psychotropic Substances in 1971, adopted by the United Nations Conference at Vienna in February 1971. These are the three important international conferences that's been mentioned in the section 2 of the Narcotic Drugs Act. So, we can clearly understand pertaining to the international treaties, pertaining to the international conferences, and after entering into the treaty, agreement, conventions, the India is empowered to enact such laws, whatever has been accepted there, whatever the decision that's been taken in the international conferences, and to combat all these activities of this terrorism or international trading or international trafficking or international money laundering, the acts could be enacted, and in accordance with that, these acts had been enacted. So, you have to integrately you have to see, but there are different agencies for the purpose of investigating into that offences. Suppose if one is connected with another, where they will go? If one is so inextricably if it is connected, then the precedents will come under section 19 of the NIA Act, and it has to be handed over to the NIA Act. That's what this NIA has been given an importance over and above the other acts that's been enacted for the purpose of implementing or giving effort to enforce the international commitments. Okay. These are the three acts. Just for the browsing, just for glance, I just went through it, and then we'll go to the next part of the lecture. First part I said about the act, the case, that is the Pragna Singh Thakur's case, in which all these issues had been raised. We can take it as Pragna Singh Thakur, Chandrapal Singh, and it's a Bombay High Court delivered judgment. And you can take it and you can also read that these are the prime issues that's been raised. But the issue primarily is that all these agencies are police officers, especially this NIA, because they are concerned with the NIA. This is especially it's a police which will fall under the entry number 2 of the state list. So therefore the parliament will not have competency to enact that law. So that's what the prime contention which has been answered in that judgment. We will also go through that. The provisions of the constitution which empowers the parliament to enact the law. Okay, we will go to the next. Before getting into the constitution, I would like to highlight certain fundamental aspects of fundamental factors which require to understand that constitution purpose. The thing is that before going into the constitution, I would like to point out that there's a concept of sovereign state. The sovereign state is a state which is having all its power within itself. We are not subordinated to anybody else. It's called in Tamil, it's called Irayanmai. This sovereign is now, it's going to be affected, it's intolerabilities. So therefore, such a special act of NIA that's been created. For the purpose of sovereignty, if you read the sovereignty, then you will have to, next question would be that you will have to go into the what are the features and what are the characters of the sovereignty. The sovereignty, if a country to maintain its sovereignty, it should have a legal regime. In the legal regime, it will be penal laws will be there, civil laws will be there for the purpose of maintaining the peace and order, for the purpose of maintaining the peace and order of the people. So in case of the penal laws, why would the sovereign country should have a penal law? Then the question will arise. Why should the sovereign country should have the penal laws? The penal laws are the purpose of first protecting its sovereignty. I have to protect my sovereignty. Somebody may transgress and take out my land. Something what happened in this Pakistan occupied territory, POK. Somebody may get into Arunachal Pradesh. The China will take part of the land. So therefore, my sovereignty has to be protected. My integrity has to be protected. My territorial integrity has to be protected. My state integrity also should be protected. My citizens should be protected. How? You will protect all the land and other things. You will leave the citizens in lurch. It will not so. So you have to protect the citizen. It's a commitment of the state to protect its subject also, and to penalize the people who are offending the laws. So these are all the characters, these are all the things purpose for which the penal laws are required. Penal laws are required for the purpose of maintaining peaceful regime in the country. And apart from protection of the sovereignty, protection of the security, protection of the integrity, territorial integrity, and this protection of the citizens and all to be included. Okay, if for the purpose of protection, what is the force you will have? You should have the police force. This police force is the concept of British regime. It is a Commonwealth concept. The concept of police was a Commonwealth concept. So therefore the police regime came. If the police regime came, what is the power that's been entrusted with the police? What is the power that's been vested with the police for the purpose of protecting all these 6 classes, protecting the sovereignty, protecting the integrity and all. So the police had been vested with the sovereign police power. Sovereign police, what is the meaning of the sovereign police power? The sovereign police power includes the power to arrest. Sovereign police power, by means of the convention I am saying, I am not just for a time I am keeping apart that CRPC and other criminal laws which gives the procedure laws. Sovereign police power in general, they have the powers to arrest, powers to detain, powers to summon, powers to search, powers to seize, powers to recovery of any materials that is involved in the crime, and power to produce a report or charge it before the court of law and to prosecute them. All these powers are included in the sovereign police power. These are the powers, these are the 4 concepts which are integrated, and it could be termed as a features and characters of the sovereign state. So this you have to please keep it in your mind. If you go to the police, what is police? Under entry number 2 of the state list, what is the definition of the police? What would be the characteristics of the police? What is the features of the police? In the recent judgment, in the recent case which we dealt with along with Sir, Mr. Nam Sir here, and this is a case called Tofan Singh. Judgment has been delivered by Honorable Supreme Court. You please go through the judgment. We made an elaborate discussion pertaining to that the officers who had been appointed under the Narcotic Drugs Act. This Narcotic Drugs Act officers are whether police officers for the purpose of section 25 of the Evidence Act. Whatever the statement, confession statement, any statement admitting the guilt, if it is given to the officer who had been appointed under the Narcotic Drugs Act, whether it is hit by section 25 of the Evidence Act, because it's a statement which is given to the police, it will amount to the confession which is given to the police. Therefore, it is not admissible in court of law. That was a prime dispute that was raised before the court, that they are all police officers. Whatever the statement and the confession that's been given to the officer who had been appointed under the Narcotic Drugs Act, they are all police officers, and whatever the statement that's been given, it cannot be taken into consideration. It will not be admitted in the court of law. That's what the prime contention which we raised before the court, and we also prepared a very detailed written submission. Sir has classified and categorized 4 varieties of police officers. Sir has said that very detailed. We prepared that written note, everything. First, already I said that police officer will have this power of the sovereign police powers, in which he can exercise the kind of powers which I said. These powers could be exercised. As far as the categorization is concerned, the first category would be the real police, a local police, a police who really exercise the powers of the police. He may be called a uniformed police. He is a first police, first category. The second category would be the police who could be deemed to be the police officer. He will not wear the formal uniform, but he will have all the powers of the police officers. He is a deemed police officer, and he will exercise all the powers that's been conferred on the actual police. He will exercise all the powers that's been conferred on him by Criminal Procedure Code. Criminal Procedure Code, you have to keep it in your mind, it's a concurrent list, entry number 2. So it is a central subject. It may be central subject or it is state, but usually central will be enacting it. Some minor amendments will be carried out by the state. Therefore, it is a central subject. So though police is different, coming under, even if it is a state police under entry number 2, they have to use only this Criminal Procedure Code. Even if it is the CBI or even if it is the NIA who are dealing with an offence, who are investigating with an offence, they have to make use of only the CRPC for the purpose of investigating it. So here you have to understand that the police officer, while undertaking the investigation, they have to adopt only the procedure that's been enshrined or stipulated in the CRPC. So this is the second category, is the deemed police officer category, who also will be using this CRPC. Third one will be the officer who are akin to the police officer, but they are not really a police officer. There will be an officer who will be appointed under the particular act, any act. For example, we can say that act that is the Food and Security Act. They have all the powers of going and searching a premises. They can recover the property and they can initiate proceedings as if they are the police officers. And this category is called akin to the police officers, who are not police, really not police officers, who are similar, almost similar or akin to the police officers. They have the powers similar to the police officers or akin to the police officers. This is the third category. Fourth category is an officer who is actually not a police officer, but he will have some powers of the police officer as if he is as that of the first category, the actual police officer. So this is a fourth category, where you can say that NDPS officers are the fourth category. All these officers in the fourth category, except number one, the local police or the actual police, all other police are not designated as a police officer, but they are empowered with some powers of the police officer, actual powers of the police officer or some powers of the police officer for the purpose of investigation. This is what has been dealt ever since from 1960s onwards. I will give you 4 case laws in that, and subsequently 4 case laws. 1 case law is now settled, then subsequently 4, or totally about 9 case laws I will say. Please go through that. Please have an understanding about this, what is policing and what is the concept of policing. And first it will start from the Barakat Ram. It may be in 1960s somewhere. First one is Barakat Ram. If you want to please note it down, I will tell Barakat Ram. Then Badku Jodi. Third one is Iliosis. Fourth one is Ramesh Chandra Mishra, R.C. Mishra. Fourth one is Balkishan. Up to these 5 cases, the concept that was evolved is, what is the dominant purpose for which the police force was created? Now all these 5 cases, what is the dominant purpose? The dominant purpose is for the purpose of investigating or purpose of detecting and investigating the fraud. You can also prevent. You can prevent, detect, investigate the crime. So for 3 purposes. They will also be empowered with the judicial powers. These were the 2 categories, two criteria that has been imposed for the purpose of, but it was not made as a dictum or it was not made as a law, but it was only a passing remarks that was going on up to these 4 cases, and there was a discussion. But in Balkishan case, that's the 5th case. First 4 cases I said that number 1 is Barakat Ram, number 2 is Badku Jodi, number 3 is Iliosis, number 4 is R.C. Mishra, Ramesh Chandra Mishra, number 5 is Balkishan. In the Balkishan case, what was decided by the Supreme Court, as per the Badku Jodi, there was a passing remarks saying that if the officer appointed under any act, if the officer is having the power to file a final report under 173, class 2 of the CRPC, then the officer will be classified as a police officer, whatever may be the act. If the act empowers him to file a final report under 173(2), then this officer will be a police officer. Even that it has not become a dictum, it was a passing remarks, and as that of the Badku Jyoti's case. Then here, in subsequently after this 5 judgment, in the recent past, there were 2 judgment which was passed by the Supreme Court, saying that NDPS officers are not police officers. Therefore, section 25 will not be attracted. Section 25 of the Evidence Act will not be attracted. These cases are, one is Rajkumar Carwell. Second case is Kanyalal. Rajkumar Carwell is the first case. Second case is Kanyalal, in which the court decided that officers who are investigating under the NDPS, Narcotic Drugs and Psychotropic Substances Act, are all not police officers. They are simply officers in conducting the investigation. Therefore, section 25 of the Evidence Act and the statement which is given during the investigation is also will not be hid by section 25 of the Evidence Act. This is what the law that's been settled by the Supreme Court in these 2 cases. Then there comes the Noor-Agha, a case called Noor-Agha, wherein, quite contrary to these 2 judgments, Rajkumar as well as Kanyalal, they said, no, the officers who are investigating the offence under the narcotic drugs are also police officer, and the section 25 of the Evidence Act is squarely applicable in this case, and therefore whatever the statement that's been given during the investigation, it will be hit. This is a Noor-Agha's case. We relied upon the Noor-Agha's case for the purpose of this case, and we submitted our written submission. And finally in Topan Singh's case, very recently, Topan Singh's case, judgment came about 1 month back. Ultimately, the court held these officers are police officers, and whatever the statement that's been given to the police officers are hit by the Evidence Act, section 25 of the Evidence Act, therefore cannot be admitted as the evidence at all. This is what the quite recent judgment. So please note down this. These 4 judgments which is subsequent to Balkishan cases, Rajkumar Carwell, second one is Kanyalal, third one is Noor-Agha, the fourth one is Topan Singh's case. These are the 4 cases which you will have to bear it in your mind for the purpose of understanding what is the police and all. So up to here, we are dealing with the police. What is the police? What are the characteristics of the police? And for different enactments, different acts, different character and different features will be given to the police officers, and different powers also will be given to them. But whether they are really coming under section 2 or not, entry number 2 or not under the state list, that is a question that we are going to now deal with that in the Constitution. Okay. Then we will go to the Constitution portion of the Constitution. Well, sir is connected, or sir's connection is lingering around. Sir is there? Yeah, if you want to disconnect and connect, you can connect by Parthiban. We will have a third. Yeah, sure. No, nothing to worry. Sir's link is lingering. Third category would be the officers who are akin to the police officer, who will have a similar powers of the police officers, like that of the food safety officers. And the fourth one will be that the officers who are actual powers, they will have an actual powers, they are not really a police officers. They are almost similar to this NDPS officers who are invested with the powers of the officers in charge of the police station under section 53 of the NDPS Act, as well as 42 of the NDPS Act, for the purpose of conducting, that is a limited one. Here it is officer in charge of the police station, but there it is a limited one, saying that search, for the purpose of search, you can seize recover the material, arrest somebody and put a report to the person who has entrusted the job to him, to his higher official. This is a 42 section. So these are the four varieties of police officers which we have submitted in our written submissions to the Tofanson's case. So this just you keep it in your mind. These are the things. Now we are really going to delve into where is about the competence of the enactment, the competence of these enactments in the Constitution, which part of the Constitution empowers the Parliament, gives the Parliament the competence, power to the Parliament, legislative power to the Parliament, for the purpose of enacting this legislation, which is a most interesting part, which you will have to bear it for some more time, which I will conclude in another 10, 20, 25 minutes. And for this purpose, first you will go into this schedule number 7 of the Constitution, which is nothing but the partition document. Bhagapiruvinai Pattam. Tamil la solnona Bhagapiruvinai Patram. Yaar yarku Bhagapiruvinai? Between whom? Partition between whom? Partition between the Parliament and the states. There are several states, nearly about 30. So the power has to be now divided. So what are the powers you possess? What are the powers I possess? What are the subject over which I will have the power? What are the subject over which the state will have the power? Is my voice is clear? These are the three lists. Yeah, these are the three lists. List number 1, list number 2 and list number 3. List number 1 pertains to the subject that's been enumerated for union list to have the exclusive power to enact laws. And list number 2 is a state list, which is an exclusive power to the state to enact laws. Third one is the concurrent list, in which both Parliament as well as the state, both will have a power to enact laws. So this is the partition deed of the Constitution of India, the 7th schedule of the Constitution, which contains so much of subject matter. You can assume, for better understanding, there are about 200 acres of land. For 97 acres of land that's been given to the Union. Some 66 acres of land that's been given to the state. Some 47 lands are there which are kept as a common pathway. So in which both Parliament can walk, both as well as the state also can walk. This is for the purpose of better understanding. So Parliament will have an exclusive power. See, there are, as far as 7th schedule is concerned, you have to read the 7th schedule along with the 246 of the Constitution of India. Before 246, just have a glimpse over the 245 of the Constitution of India. 245 says the Parliament shall have power to make law for throughout the territory of India or part thereof. Even for some state they can pick and choose and they can enact law. Sometimes they can choose the entire India for the purpose of enacting law, and the law will have a enforceability throughout the territory of India, or it may be confined to some part of the India. So this is what the 245 says. In the 245, then this is the second part which I felt it's important. Just go through that second part of that 245. In the second part, in the clause 2, what it says, no law made by the Parliament shall be deemed to be invalid on the ground that it would have extra territorial operation. So here it's so important. India is ruled by central government. Central government is having some territorial jurisdiction. And this law, which gives power to the central government, which can take its law to be operated beyond the territorial jurisdiction. That's what the clause number 2 says. I'll once again read it, which is so important. No law. See, this is so important and relevant for the purpose of these acts. We are investigating not only in India, and also we are going abroad. And the officers in charge of the police, officer who have been appointed under NIA, his power is subject to whatever the power that's been given by the central government. Apart from that, its power is also subject to any international convention and agreements, as well as any local law of the country in which he is carrying out the investigation. So this has to be read along with this amendment, Amendment 2019, which had been, I hope that this Amendment 2019 would have been brought into force only because of this clause 2. This clause 2 says, no law made by the Parliament, a law made by the Parliament shall not be deemed to be invalid. We can take it in this way. The law made by the Parliament shall not be deemed to be invalid on the ground that it would have extraterritorial operation. It means that even the law is made for extraterritorial operation, that law is a valid law. This is what the 245(2) says. 245 class 2. 245 class 1 is simple. Parliament has power to make law throughout the territory of India or even the part of it, for both. This is the 245(1). But 245(2) goes beyond the territory. He gives a beyond territorial operations. Power for extraterritorial operation power is also provided in the class 2, which could be compared. This 2 could be compared along with the preamble which I have stated. This act is enacted for the purpose of protection of the sovereignty, integrity, territorial integrity, security of the state, security of the nation and all. And even for maintaining the relationship, should not destroy any offense, should not destroy the relationship of India with a foreign country. For all this purpose, this second clause could be, the clause number 2 of the 245 could be used. This gives a power to the Parliament. I can say that this gives a power to the Parliament. Okay. Then we will come to the 246. 246 should be read along with the 7th schedule. 7th schedule, I said there are 3 lists. List number 1, list number 2, list number 3. List number 1 is a union list, 2 is a state list, 3 is a concurrent list, which is what specified here in the class number 1, 2 and 3 here. But class number 1 and 2 and class number 3 will be divided into subject to and notwithstanding to. There where the confusion will occur. You have to take a clear picture about it. So here, if you read 246, if you have the book Constitution of India, please read the 246 class number 1. The class number 1 will correspondingly, it will deal with the list number 1 of the 7th schedule. The subject matter in which the Parliament will have an exclusive power. Is my voice right? Clear? Any one of you? Yeah, very good. Very good. This 246(1) corresponds to the list number 1. So, what is stated in 246(1) is that notwithstanding anything in the concurrent list, notwithstanding anything in the state list, the Parliament will have a power. That is, the Parliament power will prevail over everything. I am the superior. You are all subordinate. Your concurrent list, whatever the concurrent list is there, concurrent list you are subordinate. State list is there, state list is also subordinate. You cannot have a primacy over me. If at all, if you create any law inconsistent to my Parliament law, to the extent of inconsistency, it is void. That is 254. We will come to that later. So, what are the provisions which we are going to deal here? The articles. What are the articles we are going to deal with is 245, 246, 248, 249, 250 also to some extent 250, then 253 and 254 and 365. These are about 8 articles which I will have to enlighten to you for the purpose of the Parliament is having primacy over all other institutions. Parliament can grab or take away at any time in the interest of nationalists any power that's been vested with any subject that's been vested with the state list under the list number 2. That I will come to that later. Before that, now we are in the 246(1). 246(1) is notwithstanding anything stated in the class number 2 and class number 3.